afternoon, everyone. It's lovely to have so many of you signed up for today's webinar, and it's nice to have you all listening to me this afternoon. What I'm going to talk about this afternoon is redundancy, because I feel like it is a bit of a hot topic. Unfortunately, it is the way of the world that sometimes we do have to go through redundancies as an organisation, and often we do like to put it slightly on hold during the Christmas period, and we tend to pick it up more in January. So for our first poll, I'm going to get Liz to put that up just to see how many of you as an organisation, how many companies out there are considering making redundancies in 2016. So if you'd just like to fill in that poll if you can with your yes or no, that'd be really appreciated. And I'll just wait a couple of minutes whilst you do that. So we're getting some interesting responses there, and actually the majority of people listening today are considering making redundancies. We've got sort of 75% to 25% no. It's going down slightly to 73% yes, 26% no. So that's really interesting, and Liz is just going to broadcast those results just so you've got an idea. It's just useful for me as well just to see who is contemplating this going forward for 2016. Whilst I'm just on the redundancy side, what you may also find useful is that ACAS has issued some really useful guides on redundancies. If you ever are struggling at any point and you want a bit more guidance, obviously you can speak to your legal advisors, but if you're wanting some sort of down-to-earth, easy-to-understand guidance, then ACAS has issued a handling large-scale redundancies, the collective consultation guide, as well as handling smaller-scale redundancies, so that's where it's less than 20 employees. So for the webinar today, I'm going to focus on looking at redundancy itself, the definition and a fair process. Liz has just put up there, thank you Liz, just a disclaimer, just to sort of cover off, of course. I'm giving you as much information as I can today, but this doesn't constitute legal advice. And if you have any particular issue, it's always worthwhile double checking it with a legal advisor or whoever you tend to use, just to make sure that you're doing everything okay and as per the legislation. So we're going to be looking, like I said, definition of redundancy, fair dismissal, the redundancy process, then moving on to payments, covering off slightly the tribunal claim aspect, and then just some points to remember really, just sort of some tips for you at the end. So I'm mainly focusing on those issues. I will briefly touch upon collective consultation, but that isn't the main focus of my webinar today. But later on in the webinar, I will do a poll to see if any of you would prefer, or not prefer, if you would actually like a webinar in the future on collective consultation. So we'll come to that when I get round to that slide shortly. So starting off then, the first thing that you need to consider as a business when you're looking at redundancies is the definition for redundancy. So you need to consider whether you actually do have a genuine redundancy scenario, and that's the overarching issue that you have in these matters. Now, redundancy definition by law is set out in the Employment Rights Act 1996. So you're looking at section 139. And in that section, you've got three types of redundancy. So you've got the classic business closure, the other issue where there's a workplace closure, so the business itself isn't shutting down, but a place of work in which the employees are based is shutting down. And then you've got the other one, which is the reduction of workforce, where you've got a reduced requirement for employees to do work of a particular kind. And that could cover things such as where you've got the same amount of work, but you need fewer employees to do the job. So it could be something where a managing director absorbs the duties of a general manager, or where you've got less work and fewer employees needed to do that work, or where you have less work but the same number of employees are needed, so there might be a reduction in hours or something like that, signalling a redundancy scenario. So this is the first thing as a business you really do need to consider: in which definition does it fall? Is it a business closure? Is it a workplace closure? Or is it a reduction in the number of employees? And generally speaking, just to give you a bit of a commercial overview here, if you are unlucky enough to end up in a tribunal for a redundancy-based dismissal and an employee is bringing an unfair dismissal claim, the tribunal will not generally look behind the employer's decision or require it to justify how or why it's come to this decision for the redundancy. So as long as you can say you had a genuine redundancy scenario and you applied your mind to it, the tribunal will accept that. So it's just something to show that as a starting point you made that consideration in your mind and you applied it fairly and reasonably, and as long as you've done that and as provided it's a genuine reason for the dismissal, the tribunal won't go behind that and look into it as a business aspect. So that's your first port of call, is the redundancy definition. And then if we move on, what I'm just covering off next is just some overview on a fair dismissal, because I think this is important when you're looking at redundancy dismissals. So the first thing to really consider is your 2-year qualifying service. So obviously now employees do require 2 years service before they gain the rights for unfair dismissal. Obviously be aware of any potential discrimination element, because that's a day one right, so they don't need a qualifying service to bring a claim for discrimination. But where it's an ordinary unfair dismissal, they do need 2 years service. So that's something to bear in mind if you are looking at making redundancies where there's less than 20 employees, and actually you maybe only need to make a couple of redundancies and you've got people working for you with under the 2-year service. It may be relatively simpler to go down that route rather than involving the whole workforce in it. The other thing to bear in mind is that redundancy is one of the 5 fair reasons under Section 98 of the Employment Rights Act 1996 for dismissal. So it does form one of the fair reasons to dismiss, along with the other 4, which is conduct, capability, some other substantial reason, and illegality. So as long as you've got a genuine redundancy scenario, you will tick that box for having a fair reason. The second box to tick in terms of a fair dismissal is that you must follow a fair and reasonable process as set out in Section 98 of the Employment Rights Act 1996. Now, on redundancy, there is a leading case on reasonableness in relation to how you go about a redundancy-based dismissal, and that's the Polkey against A.E. Dayton Services Limited. It's a 1987 case, and it's a case that went all the way to the House of Lords. And what the House of Lords said in that case is that an employer will normally not act reasonably, and a dismissal will be unfair unless it warns and consults employees or their representatives about the proposed redundancy. It adopts a fair basis on which to select for redundancy. So in that case, the tribunal stated, or the judges in the House of Lords stated, that an employer must identify an appropriate pool from which to select potentially redundant employees and must select against proper and fair criteria. And finally, employers must consider suitable alternative employment. So they must search for, and if is available, offer suitable alternative employment within its organisation. So that's really clear guidance there for you as employers, or where you're advising employers, to show that as long as you warn and consult, as long as you adopt a fair basis on which to select for redundancy and consider alternatives to employment, then you pretty much will be okay in terms of making sure that you do fit within that criteria of following a fair and reasonable process. And then just moving on to the next slide, I've just put this up here because I always find this to be really important, and I often get some of my clients phoning me to say they're having an issue with a member of staff, they're not performing very well, for instance. But what they're thinking of doing is, instead of going through a performance management process, which is long and drawn out, they're thinking of just creating a redundancy scenario to get around the poor performance and dismiss them for redundancy rather than a capability-based dismissal. And what my advice always is that redundancy must be the real reason. So don't dress up a poor performance as a redundancy. So don't create something that doesn't exist. Because when it comes to the employment tribunal scenario, and if you are challenged as to whether there was a genuine redundancy scenario, when you've got your hand on the Bible or whatever book you would wish to swear on, if you, hand on heart, cannot say there was a redundancy scenario, then you are going to fall foul of the previous slide where we talked about having a fair reason for dismissal, because it won't be a genuine reason. So it is always a two-step process, always have a fair reason. So if it is redundancy, it must genuinely be a redundancy scenario, and you must always act reasonably in treating redundancy as that reason for dismissal. So as long as you have those 2 points in your mind going through this matter, you should always be okay. The next thing to then consider, so once you've considered that you've got a genuine redundancy scenario, is to establish how many redundancies are being proposed. Now this is really key because this will establish the process that you need to follow through. So if you have 20 or more redundancies, where you've got 20 or more redundancies being proposed in a 90-day period, then collective consultation obligations will arise. And I will cover this briefly on the next slide. If there's fewer than 20 redundancies being proposed, then it will be necessary to follow a fair procedure in relation to each employee. And this is really going to be my main focus for today. Before I do the next slide, we might as well do the poll just to see if any of you would benefit from a webinar in the future on collective consultation. Like I say, I will cover it briefly on the next slide, but it's not going to be in a huge amount of detail, it'll just be very briefly. So if any of you would benefit from this collective consultation, and this is where you have to engage with trade union or if where there's no recognised trade union with elected employee representatives, where 20 or more redundancies are being proposed. So I'll just give you a couple of minutes to fill that in. So actually we're getting quite a resounding yes to that. About 88%, 90% are saying you would like a webinar on that. So I'm sure we can sort that out. A date for the new year for that, that's not a problem. Yeah, I think nearly everyone's voting yes. So I think Liz will probably broadcast that poll in a second. Yeah. Oh, well, thank you for your information there. Like I say, I'll just cover this briefly now on collective consultation. So the requirements of collective consultation are set out in section 188 of the Trade Union Labour Relations Act 1992. So like I said, section 188 of the Trade Union Labour Relations Act 1992. I've just had one question just come in just before I carry on with the slide from Alison saying, does the continuous service of staff influence whether they're counted in the 20? I think it will be, Alison, because if you dismiss somebody, cause it's basically where the obligations of collective consultation arise is when you're making redundancies within a 90-day period. So I think it will be relevant when you're looking at the 20 employees or not. So that's the act that you need to look at. And basically, with collective consultation, the duty arises where the employer is proposing to dismiss as redundant 20 or more employees at one establishment within a period of 90 days or less. And so, under this legislation, consultation must begin in good time. However, certain minimum time limits apply depending on the scale of the redundancies proposed. So whilst consultation must be in good time, there are certain timescales that are set down by the law. So where there's 100 or more redundancies being proposed, consultation must begin at least 45 days before the first dismissal takes effect. So less than 100 redundancies but more than 20. The minimum period which must elapse is 30 days. Consultation begins with the provision of information on the proposals to the representatives. So you do inform and consult with the representatives, that's either the trade union representatives or where there's no recognised trade union, elected employee representatives. And then as a minimum, consultation must be undertaken with a view to reach an agreement on ways and means of avoiding the dismissals. It's all about consulting, as a way to avoid redundancies. As part of the collective consultation process, you are as an employer obliged to notify the Secretary of State on a form HR1. This is where you're proposing to dismiss as redundant 20 or more employees at one establishment within a 90-day period. So there's quite a few obligations there for you. And then finally on that slide, I've covered off the protective award, which is something that you must also be aware of. And this is an award which the employment tribunal may order an employer to pay its employees where the employer has failed to inform and consult the employee's representatives under the collective consultation legislation. And it's basically a week's pay for each week of the protected period, and there's no cap on a week's pay, and it's basically up to the employment tribunal to decide how much protective award can be, but it's capped. Well, the maximum protective award can be 90 days pay. So that's something to bear in mind that each employee would be entitled to if they aren't collectively consulted as they should be done under the legislation. And we've had a couple of questions to say from Gabrielle. Am I right that I read that the Woolworths case has now been overturned? Is that in relation to the establishment, Gabrielle, about the fact that each store is his own establishment? Yes, that's right. So I think, as I understand it, I think it's gone back to be heard by the tribunal. I'll have to double check, but I believe now we're back to the case where each store is its own establishment. And then a question from Amy. Is that before the actual dismissal takes place or issuing of notice? Yep, the consultation period is before the first dismissal takes effect. So that's when the consultation periods run. But like I say, I mean, that's just a brief overview on that for today. But in 2016, I can run, either myself or Marie, one of us can run a webinar on the collective consultation because it is quite an involved piece of legislation. I think it needs something that we spend a bit of time on for you going forward. Okay then, so moving now on to the sort of process and looking at redundancy process. So once you've already considered that you've got a genuine redundancy scenario and how many redundancies you are making, so say for instance it is less than 20, what you now need to sort of apply your mind to is an appropriate pool of affected employees. So first of all you need to consider what type of work is ceasing, the extent to which employees are doing the same or similar work. So in that area, who is doing the same or similar work, the extent to which employees' jobs are interchangeable. So you may have a number of employees within a job description. So you need to consider, are the jobs similar or the same? Are they interchangeable? Do they all need to be in the same pool? You may need to consider different sites as well, because it may be that the employees work between sites or can travel to other sites. You need to also, maybe consider that. Sometimes in pools there may only be a pool of one. For instance, if you need to lose a managerial position and there's only one person doing that managerial role, so they'll automatically, unfortunately, be provisionally selected. But where there's a number of employees, you may end up with a pool of potentially redundant employees. And what you do when you have a pool, so say for instance you have a pool of 10, but you only need to make 2 redundancies, you'll then have to establish objective selection criteria in order to be able to score those employees. So your criteria does need to be objective, and it really does need to be capable of independent verification. So it's useful often to have HR records, or where you have these tools where you can record information online and then you can download it. For instance, when you're looking at absences or disciplinaries, anything that you can have that's measurable is always a great criteria to use. So I put some suggestions up there. So you could have things like performance and ability. So appraisals are often quite key in those types of scenarios. Length of service, you could look at that, and I'll come on to last in, first out in a minute. Attendance records, where you've had a high number of absences, that could be a factor. But be careful with this to make sure that you do ignore any disability-related absences or any pregnancy-related absences, because that could give rise to discriminatory issues. Disciplinary records, often a great one if somebody has had some disciplinary in the past. And then, on last in, first out, this used to be, or it did used to, be quite a common way of dealing with redundancies and quite a common method of redundancy selection. Going forward, I think it is still used, and tribunals will still accept it, but it's more likely to be viewed as acceptable if it's used part of a balanced set of criteria. So if it's not the only one, or if it's a tie break where all the other factors are equal, so there's nothing else you can differentiate people on other than last in, first out. There was a case, the Rolls-Royce PLC against Unite the Union in 2009, in which the Court of Appeal did hold that using length of service in redundancy selection matrix was lawful. So whilst you may think it's inherently indirect age discrimination because maybe the younger people are going out first or something like that, Rolls-Royce could objectively justify it because there was 2 legitimate aims to using that type of selection criteria. The first was maintaining a stable workforce and also rewarding loyalty. So if there is, ways that you can objectively justify it, then that's usually fine. Again, with looking into the genuine reason for redundancies, the tribunal will not substitute the selection criteria it would have chosen. So they won't look at what selection criteria you use and change it and say you should have used something else. The only time they will ever interfere with the selection criteria that you use is when no other reasonable employer would have used that selection criteria. So if you use something really unfair, so if you based it on attendance and you've used maybe disability-related absences or something like that, something which has been completely unfair and it's resulted in someone being chosen for discrimination reasons or something like that, then they may jump in there. The other things to consider as part of the process before you really get it underway is voluntary redundancies. It's always worthwhile asking for volunteers for redundancy, because you never know other people's circumstances. Other people may be really willing to consider something like this. And particularly if you're willing to offer a bit more of an enhanced package, you could often get it tied up quite easy in a process and maybe get tied up in a settlement agreement, which I'll touch on at the end. The other thing that you must also consider is alternatives to redundancies. So things like alternative vacancies that you might have going within your organisation and making sure you're offering these to your employees who may be impacted by redundancy, or just general alternatives. So if you're offering a lot of overtime, maybe consider reducing that, or maybe where you could look to change people's working hours or reduce hours. If people would agree to reduction in hours, that might try and save some jobs. So it is part of the redundancy process that you must consider alternatives, particularly alternative positions. And then moving on then, just to looking at the process really. I mean, in terms of going through the process with your employees, what I would always say is that you meet with all the employees who may be redundant first of all, meet with them as a group. I call that your at-risk meeting. So you sit them down to explain, this is a situation facing the company, this is the reason why redundancy may be needed. Talk to them about the fact that you will look into alternatives, and you could maybe mention it. And also ask the employees to consider any alternatives they may have. You know, they may have some suggestions that you hadn't even thought of. As part of that process, please always remember to include absent employees. So any of those who are sick or from maternity leave who may be impacted by the decision, make sure they are fully informed as well, because they need to be kept appraised. So once with them all, talk to them about the situation, discuss the next steps, what's going to happen next. So in terms of having to pool employees and do the selection criteria, talk about that. And then, you know, take a minute of the meeting, make sure everything's documented, and just hand the employees a letter at the end of the meeting to confirm what was said so they're aware and confirm what the next stages are. So you've had that at-risk meeting with them all, and then the next stage would be where you have got a pool of employees and you do need to carry out a scoring exercise, is to basically do that. So you do the scoring exercise, you look at your selection criteria and score them. And I would always say get 2 line managers or 2 managers where possible to conduct that scoring, to have somebody do it and somebody do a check, so then it's fair, isn't it really? Once you've then carried out that scoring activity, you will then know who should be provisionally selected for redundancy. So whoever's scored the lowest is generally the people who are invited to the next stage. So you would then write to those people to say they've been selected for redundancy and invite them to a first consultation meeting at which you discuss their provisional selection for redundancy. You talk to them about the scoring. So if you've gone through the selection criteria scoring with them, if they're in a pool of more than one, talk them through it, ask them for their comments. You know, if they challenge the scoring or make any suggestions, then it may be that you have to rescore following the meeting. Talk to them about any opportunities for alternative employment at that meeting. If there isn't any, then, you know, that's fine. You can say there isn't, but say that you'll still consider looking and, you know, keep a lookout for any that may arise, and also ask them for their comments. And I mean, the most important thing that you can really do is listen to the employees at the meeting and make sure you fully note down exactly what they're saying. And if they do make suggestions, make sure that you are looking into them. I would generally recommend that the employee be accompanied at that meeting by a work colleague or a trade union representative. And then, as always, make sure you minute the meeting, make sure there's a full record of what transpired at that meeting, and then you can always forward that as well, which I always recommend, to the employee, so they get a confirmation of what was discussed via minutes, and then they also get a letter confirming what was discussed as well, so it's clear. And then once you've gone through the first consultation meeting, you will then follow up that meeting. So if at the first consultation meeting the employee made suggestions on the scoring, or they made suggestions on ways to avoid the redundancy, then follow that up, you know, look into it and follow it up with the employee. If they did make representations on the scoring and you obviously then have to go back and carry out a rescoring, it could be that other scores have then changed. So what can sometimes happen, and I have seen this happen, is the person who was provisionally selected is no longer in the bottom 2 or the bottom 3 or however many people you're looking to make redundant, and actually they move up and then you have to invite somebody else. So just be aware of that. But once you've had the follow-up meeting, and say if it is still them, they are still the person that's provisionally selected for redundancy, you would generally hold a second consultation meeting with them. You'd invite them to that meeting in the usual way, give them right to be accompanied by a work colleague or trade union rep, and then if there is genuinely no alternatives, there isn't any other way to avoid the compulsory redundancy, then you would confirm the decision reached, go through the redundancy package with them, and again minute the meeting and confirm that decision in writing so it's clear when they're going to be terminated, what payments they are to receive, and also offer them the right of appeal. So they've got the right to appeal that decision. We've just had a question come up from Gabrielle say, what if someone does not want to attend the first consultation meeting? I would say obviously make every effort to get them to attend, because it's really important for them to attend, but if they don't want to engage, then all you can do, Gabrielle, really is write to them to say, look, we wanted you to engage in this meeting for these reasons. We've tried on a couple of occasions. You simply won't. This is or any suggestions they have without them meeting with you. So I think it's just important you explain to them what the meeting's there for. But if they don't want to attend, then that's all you can do, really, is just confirm what you would have talked to them about. And then really it might be that you move pretty quickly into the second stage and having the second consultation meeting. Yeah, that's fine. Gabrielle, you can offer over the phone. Gabrielle's just said we're going to offer over the phone. That's fine. I don't see a problem with having a consultation meeting over the phone, so no problem with that. So I mean, really that's the process that you'd sort of would go through. And as long as you're fair and reasonable with it and act consistently and just apply your mind to the situation and look into alternatives, then you shouldn't really be going far wrong. Alison says, is a second consultation meeting where the notice would be given? It can be, and I would generally say yes, Alison, if there isn't any alternatives or there's no other suggestions. So if really at the second consultation meeting you've looked into alternatives, there isn't any, there's no other solution other than compulsory redundancy, you can say at that meeting, I'm really sorry, we're going to have to terminate your employment for redundancy, and then confirm, you know, what's going to happen next, basically. So either the work in the notice or you pay them the notice. If there's still room for discussion, it may be that you have to go away and have a final meeting or confirm the decision in writing, but often the second consultation meeting is a sort of meeting where the notice is given. Gabrielle's asked, but the final definitely in person. Yes, the meeting where you're basically terminating them should always be in person, I would recommend, definitely. Claire's asked, when should the right of appeal be given? At the point they're selected or at the point of dismissal? At the point of dismissal, Claire. So if at that meeting you're saying your employment will be terminated by reason of redundancy, you say to them you'll have the right to appeal this, and then you confirm that in writing as well. Right, so then moving on, just to look at some other points then really. So redundancy payments, I think we were going to do a poll on this as well as part of this, just to see if any of you offer any enhanced redundancy packages. Be interesting to see if any of you do. So if you'd like to answer the poll, that'd be great. Oh, about 50-50 or so. 51% on, going up a bit. 40, I know, going down. Going up and down. Yeah, 52%, 47% no. So that's interesting. It's a bit half and half really as to whether you do offer redundancy packages. I mean, just going through the redundancy payments itself. So statutory redundancy payment, they have to have 2 years more service to qualify for this, sorry. It's based on employees' age, length of service and weekly pay. So it's basically a week's pay for each year of service. But remember, where the employee is under 22, it's half a week's pay for each full year. Where they're 22 to 41 years of age, it's 1 week's pay for each full year. But where they're over 41, it's 1.5 weeks pay for each full year of service. So just bear that in mind. And there is a cap on the week's pay for statutory redundancy pay. It's currently £475. So just bear that in mind. If you do offer enhanced redundancy packages, then obviously you'll have to offer that as an enhancement. And then the other things that they're entitled to is the notice. So the notice under the contract, or if there isn't a contract in place, and the statutory minimum, which is a week's notice for each year of service, up to 12 weeks notice after 12 years or more service. And you can either have them work that notice or put them on garden leave, or if your contract allows, you could pay them in lieu of notice. And then the other thing they're entitled to is accrued but untaken holiday pay. And then just other considerations to take into account then when you're looking at the redundancy process. So once you've established the payments, is time off to seek alternative employment. So provided the employee has 2 years service at the termination date, then under Section 52 of the Employment Rights Act, an employee who is given notice of dismissal for redundancy has a right to take a reasonable amount of time off with pay during working hours to seek alternative employment or to arrange training for future employment. So that's something to bear in mind when you are giving a termination for redundancy and issuing the termination letter. If they are working the notice and they do have over 2 years service and the time off to seek alternative employment. Megan's just asked a question. If you're paying notice, should accrued holiday be paid up until the date of termination or the date notice would have run until? If you're paying in lieu of notice, then, Megan, you can pay up to the termination date, so the date they actually terminate with you, unless your contract says that payment in lieu of notice will allow for holiday as well. If they are working their notice, they'll continue to accrue the holiday until they actually finish with you. But it could be that you ask them to take any accrued holiday during their notice period anyway, so that's something to bear in mind. So yes, the time off to seek alternative employment is one of the key considerations to bear in mind. Trial periods as well. So if say, as part of the redundancy process, you were able to offer alternative employment as opposed to redundancy, then really you should offer a 4-week trial period unless it's pretty much similar type of role. But within the 4-week trial period, it gives you and the employee time to consider whether it was suitable, or if it is suitable rather, for you and for them, that role. And if after the end of the trial period they're successful, they will move into the new role. If unsuccessful, then unfortunately it'll be a redundancy-based dismissal. But do remember that if an employee unreasonably refuses an offer of suitable alternative employment, so if you do actually genuinely have an offer of suitable alternative employment and they unreasonably refuse that or resign unreasonably during the trial period, they will be treated as dismissed, but they could lose the right to statutory redundancy pay. So you could actually say to them, look, we do believe we offered you a suitable alternative and you unreasonably refused that, and therefore you refused, you're no longer entitled to your statutory redundancy pay. So that's something to often bear in mind that people sometimes don't realise. And then just covering off as well, settlement agreements. If as an organisation you do offer enhanced redundancy packages, or you're going to offer an ex gratia payment, or for volunteers, you're going to offer them an enhanced package just to go, there and then it's sometimes belt and braces really, get them to sign a settlement agreement, because then it's a walk-away deal. They waive the rights and then you can move on and they can move on without any risk of there being a claim. And then that just ties me nicely into claims. So just to finish it off really, just some considerations for you. When you've gone through the whole process and you've got to the end and unfortunately you've had to terminate somebody for redundancy, in terms of bringing an unfair dismissal claim, just to recap, they do have a 3-month time limit from the date of dismissal to bring their claim. They must now, as we know, use the ACAS early conciliation before the time limit expires. So hopefully you should get the heads up of any claims, and they do have to pay a fee to issue a claim. In terms of statutory redundancy payment, though, if they believe they haven't received that and they are owed it, it's a 6-month period to bring a claim. So it's 3 months for unfair dismissal, but for statutory redundancy pay, it's 6 months. In terms of the employment tribunal process, just very briefly, for the unfair dismissal, for one element of the award, the compensatory award, where it is just ordinary unfair dismissal and there's no discrimination, it is capped at either 12 months pay or £78,335, whichever is lower. So that's just something to bear in mind, because often the claim values aren't as high as what you think, because the 3 elements to a claim, or the claim compensation rather. For ordinary unfair dismissal, an employee or potential claimant would look at claiming notice pay. Now, if they're redundant, they'll have received the notice, so that claim will fall away. They'll claim a basic award, but that's calculated exactly the same way as a statutory redundancy payment, and they can't receive both. So if they've already had a statutory redundancy payment, the basic award falls away. So the main value for redundancy claims is just in this compensatory award. And for most people, they do generally tend to earn below £78,335. So the value of the claim is 12 months pay. But if they manage to get a new job relatively quickly, then any earnings from the new job are knocked off the compensatory award they are claiming, because they can't double recover. So it's just something to bear in mind. And then the final thing to bear in mind, which is often really useful, is this Polke argument. And this goes back to that claim I mentioned right at the start about procedural fairness, about following a fair process. Now, this is one of your main defences with redundancies, because if you do genuinely have a fair redundancy scenario, and there's a genuine redundancy scenario, you can't get around it, but you've gone through the process, and say, for instance, you didn't follow it to the letter, you missed a consultation, or you didn't do something that you should have done, what you could argue as an employer is that but for the process being carried out, the decision would have been the same. So you basically say, you'd hold your hands up to the tribunal and say, I'm really sorry, didn't follow the process to the letter, but even if we had have done, even if we'd have had that separate consultation meeting, that first one or the second one, or whichever one you missed, or whatever bit of the process you missed, the decision would have still been the same. So no matter what, that person would have still been redundant. And if the tribunal agrees, which normally they do, it limits the compensation the employees can then claim for the time it would have taken you to carry out a fair process. So often the compensatory award is then limited to 2 weeks or 4 weeks pay. So that's something really key to understand, because often redundancy claims, redundancy unfair dismissal claims don't really have a lot of value in them, because the employees get the notice, they get the redundancy pay, they get the holiday pay. The value is just on the compensatory award, and if it's just a procedural error, then you can normally get around that by using this poll key argument. So that's just a bit of a heads up there for you. And then just to finish off, just some, my sort of top tips really. Like I say, 2-year rule, always bear that in mind, and that's not just for redundancies, that's for any ordinary unfair dismissal. Always bear your 2-year rule in mind. Is it a genuine redundancy scenario? That's the first thing you need to apply your mind to, and go back to those 3 types I talked about at the beginning. Always keep your employees informed. I think that's the biggest error sometimes that businesses do make, is they get concerned about discussing things with employees and not keeping them informed. The more your employees are informed, the more engaged they probably will be in the process. And the same with consulting and listening. Don't be afraid to have more consultation meetings. Don't be afraid to talk to your employees more about it, and listen to everything that they have to say, and make sure you do take steps to look into any suggestions they have. Include your absent employees in the process. Like I say, anybody on maternity or on long-term sick who is impacted by this must be included. Ask for volunteers. As I said previously, you're not aware of other people's circumstances, and somebody may benefit from accepting voluntary redundancy. It may be, something they wish to consider. Paper trails, always keep your paper trails in order, because this is what you need for an employment tribunal claim. If you ever end up in a tribunal, these are the most important documents you will need, so your letters and your minutes and the scoring process undertaken. And then the final one, as always, with any type of dismissal, be fair and consistent. And as long as you're fair and consistent, you can't really go too wrong with it. And then I think that's it. And then if you've got any questions, now, or if you've got any questions later, you can get in touch with me. I'll put my details at the end. But if you've got any questions for now, I'll answer them. And all I'd like to say to all of you is thank you ever so much for signing in and listening to me this afternoon. I hope you've enjoyed it. We've got some questions coming up there. Karen says, how would you handle a potential redundancy if a person is on maternity leave? What if they are the person to be identified as dismissed? Right, Karen, if they're on maternity leave, ring them and write them. Say to them, explain the situation that's affecting the business, explain to them how it's impacting on them, ask them if they want to come in for the general meeting with everybody, because they could use it as one of the keeping in touch days. If they don't, go and see them. Say to them, look, can we actually come and visit you at home, or can we meet you at a mutual location? If they are the person identified as redundant, then they do get preference over other people in terms of alternative employment jobs that might be going at the organisation. So do bear that in mind. If it is alternative vacancies, they will get preferential treatment. But don't treat them any different to how you would treat other people who are actually in work at the moment. Just make sure you keep them involved. Kerry's asking, do you feel direct line managers should be kept away from the redundancy process consultations? It depends on the organisation, doesn't it really, Kerry? Some of the organisations I deal with, it's the line managers who have to be involved in it rather than HR, because not everybody always has an independent HR person or HR function within that organisation to assist. So it depends on the business itself and whether they can have somebody else doing the process rather than the line managers. All I would say is if it is the line managers being involved, just make sure that they are trained, and as long as they're trained on what to do in the process and trained to look for alternatives and trained to consider what the employees are saying and listen to them, then I think we should be okay. And then Stuart's asking, are those on maternity leave treated any differently? Any special measures put in place? I think, as I mentioned, Stuart, they do get preference. Well, they should be given preferences for any suitable alternatives within the organisation over above other employees. So that's something to consider. And then, as Liz said at the start of the webinar as well, Marie is going to be doing a live Q&A on redundancy in January. I think it's the 27th of January. Yeah, that'll give you an opportunity to ask any questions that you may have then, or submit any questions that you have before then if you want any particular issues to be answered. If you've got a case study, you want to talk through or something like that, you send those informations in. And then we were just going to run a final poll, I think, for any future legal webinars you think would be of a benefit to you. So we're just going to put a poll up just to see who would benefit from, and Liz just telling me to tell you to tick as many as you want. I forgot to mention that too. Tick as many as you want, and also for the other, type in the chat box any other ones that you would like. So if there's any that we have never covered or anything that you'd really like us to cover, please just type it in the chat box now, just so that we get an idea of what you would like, and that'd be really helpful for us. Just waiting for those to come through. Oh, someone's asked for settlement agreements. That's fine. I mean, I think Neil and Alison are asking about best practice in relation to dealing with those on maternity leave and long-term sick. And I think, as I mentioned before, it's just about keeping people informed. And I think what you have to get into your mind is the fact that these people are still employed. They may not be there in front of you day to day, but they're still part of the organisation. And as long as you keep them informed, as you are doing with everybody else that's sat in front of you, you can't go too wrong. And really, it's just about being accommodating. So when you've got somebody on maternity leave or long-term sick, you can ask them to come into the at-risk meeting with everybody so they feel that they're there and they're present. Or you can say to them, look, I'll come to your home or meet you somewhere else, and just make sure you just fully keep them informed of job opportunities, other alternatives. Ask them if they want to be considered for voluntary redundancy. You know, just treat them as you would everybody else, and then it should be fine. We've got some quite interesting ones. So people asking for, on the webinar front that we asked for the poll, people are asking for settlement agreements, fixed-term contracts, or without prejudice meetings. So that's really interesting. Right. Well, anyway, I think we've come to the end. So thank you ever so much, everyone, for attending. And just left from us, really, is to wish you all a very happy Christmas and a very happy New Year. And we'll see you in 2016. So thank you ever so much.
Thank you, Caroline. Absolutely brilliant. Thank you, everybody, for attending and some fabulous questions there. Have a really good Christmas. It's been brilliant this year. Some really useful feedback, and everyone's been so supportive. So thank you, thank you, thank you. Enjoy. I'm not going to sing you Happy Christmas or anything, but I am going to end the webinar. So I look forward to seeing you next year, and we will be in touch soon. Thank you very much.